My lord. Only for correction, my lord, the year should be 2024 instead of 2023. I had mentioned the matter on 9th, my lord. My lord, kindly keeps the matter because the extension has also expired, my lord.
Not in this way.
My lord, I had also mentioned the matter on 9th, my lord. The matter is
not in this way. You have
Yes.
to type it on your letter.
Yes, my lord. I will type it, my lord.
What is the what correction you are carrying?
Yes, my lord. The correction, the file is on my lord's table, my lord. My lord, the cost title, my lord. The
Very well, you cannot mention it. Come with a typed copy on your letterhead.
My lord, may I give the typed copy to my lord's officer, my lord?
First of all, give it the handwriting, replace it within 5 or 10 minutes. Call the next. No, call the next.
Item number 1.
I beg to appear for the statement. Look, this matter was adjourned for the last 3 occasions because of a pendency of SLP. It has been disposed of on 19th of April 2024, but we did not get an occasion to place the order before your lordship.
There is order security.
Back to the order has been set aside. In the writ petition, the readings are complete. So your lordship may fix a date, in after the vacation, so that we can take up the other points.
So the last direction, which
Paragraph 11.
19th April order,
9th April order, which was upheld by the division bench in 19th April.
Acha, 9th April order.
Your lordship's order is 9th April.
You are for the
Application.
So this order has got 2 parts. One, I never directed any investigation. Only
Preliminary inquiry.
So far, I recollect that
Preliminary examination,
examination that was done. A report has
been filed, but that goes, in my humble submission, if this order goes, that
goes. No investigation, nothing can be done on that. But on that, you have a FIR.
Yes.
Your CID possibly has taken over that.
Yes.
That will continue, or
and they were investigating till the order of 9th of
Let me
April.
understand that you intend to continue. You want to drop it.
There is no from 9th of April, obviously, there has not been any progress because The direction was there, and the matter was also pending before the Honorable Supreme Court
Therefore,
thereafter.
understood. But
So, my lord, we'll have to start afresh, my lord. Afresh means start from the point where it stopped.
therefore, you intend to, that I want to know.
Yes, my lord, there is no, my lord,
Second, this order has got second part of this order is that the
So cause.
yes, Bidhannagar police station.
Well, that we have filed on the subsequent date. This matter, my lord, before the stay of the Honorable Supreme Court had appeared before your lordship. When the learned DSG had filed, my lord, a report, this preliminary examination was filed on that date, which your lordship has taken note of. And also on that date, we have filed an affidavit with for the show cause,
No, now
showing the
this-
cause of the delay.
Yes.
And
Now,
the last part is the affidavit by GT.
এটা কি ওকে করতে হবে?
this second
okay,
part,
thank
is
you,
the
thank you.
inspector in charge
তুমি গিয়ে বললে?
ultimately has registered the FIR.
কি
Yes.
বললে? ঢুকায় না তো?
That FIR has been taken over by your CID.
Yes.
Very well. Have I constituted any team for this investigation?
My lord, in this matter, my lord, not in this matter. My lord, that was in the other matter.
No, in this matter.
No, my lord.
In this matter, no.
In this matter, there is no
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 investigation.
SIT has been constituted.
Considered. Now, the third part, therefore, the show cause part, if the order goes, then show cause part goes also.
Yes, my lord, there is no, my lord, qualification as to which part.
part
So
has
the
gone?
entire
Entire goes. Now, the third part, that DT was directed to disclose the particulars of the guest teachers whose appointments have been approved as regular teachers of the government aided school within the said area. That part also goes. Or where we are standing now.
my lord, as far as these parts are concerned, my lord, these as far as GTS part is concerned, your lordship
Unless, are you meaning?
can reconsider this. Why? Because I say this because GTA did not prefer the appeal, so they were not aggrieved by this part of it.
Mr. Bandyopadhyay, the problem is that if the entire thing goes, therefore a minimum evidence which is required to proceed with the matter, that also goes. That GTA, admittedly, some teachers have been appointed, guest teachers. Inquiry was that, look here, it has continued for such a long time. The admitted position, no selection test was conducted. Nothing, but what was the basic? One thing said that they were working for a long time. There was no commission working in the hill area. Therefore, we were compelled to
We were in a shortage
get
of teachers
some-
also.
at least those teachers, whether they possess the requisite qualification as per the NCT guideline, that is required to be looked into. That particulars was sought for. That also goes. If that goes also, it's a futile exercise.
My lord, we go back
Now,
to the
duty
stage
cast
prior
upon
to
you.
9th of April.
Now, duty cast upon the person who, the state who has preferred that to, that your grievance is possibly first part, rather you apprehended that the this inspection, preliminary inspection
Preliminary
may
examination.
culminate into an investigation. Because I never directed for any investigation, any preliminary inquiry.
My lord, not on the apprehension, my lord, we thought that, my lord,
Very well, very well. This
law, it
SL
could not have
scope
been
of
done.
the SLP should have been
there was no, my
Yes.
lord, our specific point was that there was no role of the CBI to step in at
very
that
well.
point of time.
Since CID has taken over, there is no
Now,
role.
my lord, in the SLP, your lordship will remember another point taken was regarding the maintainability of the writ petition. Now, that has not been decided. So, that has to be decided by your
No,
lordship.
no. Mr. Bandyopadhyay, look here, the position of this court, that you have assailed for a particular part, you are aggrieved by a part of the order, but you have not clarified before the Honorable Supreme Court. The rest part, we will continue with this CID investigation.
But that part
The
continues,
GTA
my lord,
is-
in my humble submission.
GTA is obliged to disclose how many guest teachers have been appointed, what is their required qualification. You have not clarified that.
So, my lord, that was not scope of our SLP, my lord, what the GTA is
But you
supposed to
should
do.
clarify
My lord,
that
we
when
have
the
filed,
entire
my lord,
order goes, if the
No, my lord,
entire order
it
goes.
was not, my lord, with the deepest of respect, my lord, it was not for us to clarify, my lord. It was on notice. The petitioner were there. They were there to pursue their own cause. It was not our cause, my lord. We have filed the reports before your
Well,
lordship.
it is your FIR.
It is my FIR and it has nothing to do, my lord, with regard to, my lord. We have gone very specifically on two points. One is the CBI and the
Now,
second is,
to
my lord, the
overcome this
maintainability.
situation, please file an affidavit clarifying that you intend to proceed with the CID, notwithstanding the order of the
My lord,
Honorable
we go
Supreme
back
Court.
to the stage prior to 9th of April,
Bandyopadhyay try to appreciate the situation. This entire order is not here.
my lord. But my lord, the CID investigation, my lord, if your lordship kindly goes to the orders prior to 9th of April, the CID investigation is on.
I want this clarification from your end because this has been set aside at your instance. That CID will continue. The GTA is obliged to disclose the all particulars of the guest teachers who have been appointed in this way. Only to
Well,
verify.
The second part, my lord, we cannot put it in the affidavit. We can ask from them as a part of the
How
investigation.
can if
We
I
can ask from them as a part of investigation.
because you know that ultimately they will be in the school as a teacher. So they have to satisfy that they possess the minimum qualification as per the NCT guideline.
Yes.
So that the second part of the order was intended to expose that. If any teacher is found, appointment may be irregular, but if you find a teacher is a high secondary pass, don't have B.Ed qualification, don't have, can you allow this teacher to continue?
My lord, I bow down to what is falling from your lordship, my lord. But my lord, in my submission, my lord, this part
Unless petitioners are
is to be
satisfied.
gone into in the as part of the investigation. As part of my investigation.
Your investigation has two parts.
But
Since
that will
you
only
have
take
already
out the
identified-
criminality of it.
Yes, already identified the concerned DI at that point of time.
DI and the minister in charge, whose name has also come.
The FIR and all has been not. This is the criminality part. Now, whatever done. Now, those teachers are working whether they can at all work as a teacher or not. This is the second part of investigation.
Which your lordship has to decide. But my lord, also your lordship will have to decide.
What? I am seeking material from the authorities.
My lord, the
You are
difficulty.
going to Supreme Court and say,
Well, the difficulty is that your lordship has to decide that question and also the question
you are
that
the
whether
counsel
it
in
can
the
be. No, my lord, my name is not there, my lord. My role is only to draft, my lord, not to lead before the Supreme Court, my lord.
peculiar stand.
But my lord, the thing is that whether those orders can be passed, my lord, in this writ petition, that is also a question.
He's out of station also. Now parliament session is going on. Can we fix it after vacation any date also?
He was there. Mr. Bhattacharya was there. He should have pointed out that the rest part of this order. Where is Ahmed?
Please go to number 35, Lordship.
Yes, you are there. Why didn't you clarify that the rest part of the order that is not under challenge? Asking the GTA to disclose the particulars of the guest teachers, that is not under challenge.
It is not on a challenge.
Now, why haven't you pointed out that when the entire direction goes, then how can it be? Whether the CID investigation can continue or not?
Milad, this point, Milad, was there. The situation was such, Milad, that either you argue the entire whole thing or you not. If you want to argue, I'll admit the SLP and then proceed. So that be the situation, Milad. We are under strategically, we had to decide that no, let it be remanded.
No, I will be
So
asking.
SLP was already admitted. I'll correct my learned friend, my lord, if he is not abreast of the facts. SLP was admitted when the stay was granted and notice was directed.
Notice was issued.
Stay was granted, but SLP was
Yeah,
not.
no, and without admission, how notice was?
Milad, yes,
Stay
Milad,
granted, notice issued, and
notice was issued.
thereafter
but
they appeared.
yes, but for final hearing, it was being posted, Milad. That's the reason.
Well,
So Mr. Ahmed candidly submits that it was his choice not to point it out.
No.
Going by the situation, it was his choice.
The situation was such that court was in a position to post the matter for final hearing. So that in that event, it would delay. It would have been.
No, I want to get from the explanation from the counsel who appeared for the writ petition. Where is he? He is in parliament. You submitted that he will be available on this date.
my lord, on Monday, my lord,
সারাদিন এই
By
করবো।
Monday.
Monday, this Monday.
My lord, safest to keep it after the vacation, the parliament will also be over.
No, you do one thing. Please file an affidavit that disclosing the state of the CID investigation, stage of CID investigation, and your intention to continue with it, notwithstanding the direction of the Supreme Court, that we intend to continue with the CID investigation on this because the FIR is already there. Now, a situation.
Only CBI টা করেছে, বাকি পুরো সব regular
Mr. Samim, I'm making you off for a moment.
Monday, my lord.
Or privileged parliamentarian when he will be available in Kolkata.
On Monday.
Now, this side of vacation, I'm fixing another date when the state will file an affidavit. When?
On any day after vacation, my lord, as early as possible, my lord. My lord, in fact, when the matter is ready for hearing, affidavit is complete. So, my lord,
That is what I submitted at the inception.
Yes, Mr. Bandyopadhyay said it, but this judgment of the Honorable Supreme Court, its impact and the scope of inquiry, whether it is been limited to some extent or not, that you have to explain and I have to understand from all of you.
as you like, please.
And who is for the GTA? You are.
I am for the GTA. Mr. Subba is.
Yes, but so far this part is concerned, though the entire direction has been set aside, but a part was that to disclose the particulars of the guest teachers whose appointments have been regularized. So particulars means when they were appointed, their
Qualification.
qualifications, where from they are getting the salary, because state is saying that we are not providing them to any salary. There is a huge confusion about that. And the education comes under the GTA directly under that agreement, na?
Is not under the agreement as well as the act.
Act itself. So education
Subject to
comes
any special directions by the state.
therefore it comes especially on you. So, and of course your stand that whether you want to keep these teachers or you want a fresh recruitment process declaring all these vacancies. How many teachers were appointed roughly?
My lord, tell you. I'll tell you, Lordship, my lord.
I think there is.
Well, there were 359 volunteer teachers in upper primary, 313 in secondary and higher secondary, and 14 313. We
Now,
can go by the
after
figure
this
313.
matter,
Around thousands and all.
commission is working over there.
We have opened the regional commission, but I don't think it is operating. That I will just.
I also inquire, my lord, but it's there, my lord. It's in place.
But last occasion.
Yes, yes,
said
gazette
that
notification was
maybe
placed, my
not in that in a robust size, but it is operating. That impression was given.
Yes, yes. Its existence has been created.
Your
It has been created.
it's a regional service commission. Who is the chairman of this regional service commission? Give me the details of this regional, including the registered office, whatever. Regional School Service Commission.
The secretary.
Secretary and whatever the infrastructure they have developed, because it will be regional commission would be under your control.
Yes.
Ashun. Mr. Bandyopadhyay, learned Junior Standing Council. CID has got a separate council. Where is Mr. Nondi?
Lord,
He has
in this matter,
Mr. Nondi appeared for CID. And where is CBI?
No, I shall stop them notice.
the file the report.
Submits that the order of this court dated April 9, 2024, affirmed in appeal by the Honorable Division Bench by order dated April 19, 2024, has been set aside in SLPC 9628 of 2024. With a judgment and order dated September 24, 2024. He supplies copy of the judgment of the Honorable Supreme Court. Let it be kept with the record. Stop there. The state is required to file an affidavit disclosing the stage of the CID investigation. What was the FIR?
Lord, your lordship's FIR number.
Kindly
Lord, it
provide
is 75 of 2024.
Well, yeah, write it down on a piece of paper
My lord, I'll do that.
with section, date, PS, whatever. Okay. Investigation in respect of FIR, PS case number such and such, such and such.
Vidhannagar.
Next.
Not.
Stop.
Vidhannagar, not PS.
প্রথমে লিখুন তো Mr. বন্দ্যোপাধ্যায় first submits that state shall continue with the CID investigation
66/506
of the
and
of the such and such case number such and such. The state is directed to file an affidavit disclosing the status of the same.
7A 7 bracket छोटा है
Stop.
7 capital है
London Council for the GTA submits that the his client shall disclose the particulars of all guest teachers whose appointments have been regularized under an affidavit on the next date of hearing. Stop. Please the matter is
186
on 17th January, 2 p.m.
17th of January. 17 January.
2 p.m. Proceed out.
Most learned counsel for CBI.
Lordship,
Yes.
I tender my.
Your appearance is justified. At the fag end, everything is complete. Now you have appeared.
Lordship, I tender my sincere apologies, Lordship.
Look here, you have gone through you are there in this Honorable Supreme Court in SLP?
Lordship, we were perhaps not there, Lordship. No. We were not there. Supreme Court, Lordship, we were not represented. CBI was not represented.
Perhaps they were not parties to the.
How can you maintain it? CBI was made party here.
CBI is not a party here.
Writ petition CBI is a party.
CBI is a party. In fact,
Then they perhaps did not, they chose not to appear because we could not have gone
I
by
will-
without
I
serving.
I will take a clear instruction as to what
Then
has
you file
happened
a-
over there, Lordship.
Can you find a review?
Please go through this and just apprise me about your stand on this.
Certainly. Lordship.
I'm not going to disclose anything. Do whatever. Next in 17th, you have to answer some questions.
Certainly. Lordship.
ওটা লাস্টে ওকে বলে দিন ওখানে ফেরত চলে যাবে আগের অর্ডার গুলো দেখে নেবেন ওগুলো আরজি থেকে এসেছিল আরজিটাতে ফেরত চলে যাবে Ask Mr. Bhattacharya to be present on 17th. Otherwise, petition will be dismissed.
Milord, in item number 2, Milord, I am appearing, Milord. Pursuant to your Lordship directions on 6/12/2024, Milord, the
Hmm.
District Magistrate Cooch Behar, Milord, has appeared through virtual mode, Milord, and had complied your Lordship's order, which has been passed on 7th March 2024, Milord, which has been communicated to the bank itself also. There is a direction on 7th March, Milord, to dispose of the application within a period of 30 days. That, Milord, within the time-bound specification, the district magistrate did not pass the order, and resulting thereby, Milord, there is a contempt application, and your Lordship directed on 6/12/2024 to appear personally, and
The
also,
order dated 7th March has been complied with.
Milord, has also been served upon the bank, Milord.
None appears on behalf of the applicant. Mr. Joyji Chaudhary, learned AAG, appears virtually on behalf of the alleged contemner and submits that order dated March 7, 2024, willful violation of which has been complained of,
Milord, not willful, Milord.
has been complied with. Complained of,
Complaint of, Milord.
has been complied with. In view of such development, where is the compliance?
Milord, we have served upon the bank, Milord.
No one is there, your junior over here.
Milord, here, Milord, nobody is there, Milord. This is my,
Has
without
been
any,
complied with.
Milord, we have, by being the officer of the court, it has been served. And Mr. Ghosh has also
And-
acknowledged in the morning, I had a talk with him.
Why he is not appearing?
Because it has been, purpose has been fulfilled.
And a
As
copy
usual.
of the order comply and দরকার নেই, complied with. In view of such development, CPN 44 of 2024 হ্যাঁ দুটোই আছে, disposed of without
Milord,
any.
yeah, personal appearance also, Milord, kindly.
Where is personal appearance? Oh, he appeared virtually.
Yes, Milord, you are lawfully directed to appear virtually.
Who is he?
Mr. Meena, Milord. Arvind Kumar Meena.
I see both of them. Who is? Kindly show, raise your hand so that I can. Yes. Personal in response to the rule issued to this application for contempt or full naam din, Mr. Sri Arvind Kumar Meena, the district magistrate, Cooch Behar, is virtually present before this court. Mr. Or appearance, complied with, disposed of, rule discharged, personal appearance dispensed with.
Grateful, Milord. Grateful, Milord.
Thank you.
Milord, your Lordship has fixed another forest matter on Monday because I did not get an access, Milord, on the last petition.
Yes, Monday, please be present.
But I do not get the access, my lord. I do not know your law court officer.
No, you will be getting access. Hey, Monday to access by you know.
My lord,
Yes, thank you, Mr. Meena.
therefore, my lord, I am leaving.
Supplementary list, item number 1.
Thank you so much, sir. My lord, item number 1, my lord, I am for the petition. By your lordship's last order, your lordship remembered the Advocate General, your lordship requested the Advocate General the framing of rules.
Where is he?
My lord, Mr. Advocate General is arguing before court number 13.
With the
Judicial bench.
What was the issue, Mr.
My
Dalpatro?
lord, the issue was what is the there shall be a one format of giving appointment letters. What is the rule for confirmation?
Confirmation.
Ask him to come.
Everything your lordship was, my lord, asked my lord the Advocate General to my lord.
Yes, ask Mr.
My lord, at
Pass
12
over.
or at 12 or any time as and when the Advocate General.
No. After the tea break.
After? And
Tea
tea
break.
break.
12:15.
12.
I will call.
একটু খবর দিন মামলা করছে আমি দেখে এলাম
দেখলাম
আমাদের কত এরপরে
Congratulations.
I'm ready for it.
But I am worried about the person who has stitched it.
I know I was the last in the line because he said I has to take special care.
দাঁড়াও বাবা, বুঝেন।
My lord, Mukherjee Saab has gone for vacation. So, I have.
Your adversary has not. He cannot possibly. Now, Mr. Pincha,
My lord,
nothing to, no elaborate submission, just some few questions for you.
my lord,
Written notes. You have got the written notes on argument. You have submitted it.
my
Written notes on argument.
written notes of argument.
You have submitted already.
No, I haven't
This was earlier, Mother.
earlier. Now
That is what I
submit.
was suggesting, my lord. If your lordship, my lord, let us both get our written notes and my lord fixes a date and let us hear it out, my lord. If it's possible.
My lord,
Written notes.
written notes.
This was old one.
The old one.
এটা করেছিলাম আমি।
This is rolled one.
Old.
Please, covering all, because some new documents have come.
My lord,
After the Supreme Court, the scenario is different. Have you prepared a new one?
my lord, I have prepared, but I have got some new decisions.
And decision will come later.
Yeah,
Please.
I have prepared, my lord.
Where is that?
That
It is all covering all point
my lord, almost all point.
or not all? Yes, all point or you
My lord, every day
can
I'm
you
getting
can you make it by Monday?
No, I can give you right now. Give
Give
my
it,
lord.
give it. It is, I think that it is complete. This is complete. No more, nothing.
My lord,
This is
one more decision I want to give. This.
don't overburden it. It will be a case of remand. Don't
My lord, it is very important
forget about that.
because
Well, give it to me. Give it. Have you supplied copy to me?
Section 23 interpretation of that by a Supreme Court judgment.
Just tell me, have you supplied it to him?
No, today I got.
Supply him.
সাপ্লাই করি তো এটা কোন কপিটা
Return not signed.
কপিটা দিয়ে দিন একটা
Okay, my
I'm sorry, my lord, I have not been able to prepare one, my lord.
No, you cannot. You will be getting chance. Why should you?
আমারই তো
আমার
আপনার তো কি আছে
But ma'am, keep it in mind. I'm not hearing the suit. Don't make it elaborate. Scope of Order 7, Rule 11 is very limited. You know it very well by this time.
my
Now, in your original application,
my lord.
what are the points you took?
It is barred by law.
First of all, one
It is in violation of the lease deed.
No, let me understand one thing. So far, the government land regulation transfer, that point you have abandoned.
That, yeah,
That point you have abandoned. Because this is can be regularized. That
My
is
lord.
no serious issue. But this is violation of the clauses of the
Clauses
lease.
of the
This is number one.
number.
Because lease itself puts a restriction on transfer.
My lord,
That is your first point. That was disclosed in original application.
my lord.
Now, this what is the other point?
Other points are section 115 of the Indian Evidence Act that later came out. That I want to just,
Just wait.
my lord,
Mr. Pinja,
please
just tell me
the-
outline.
in the power of attorney given by it is a registered power of attorney registered on 2011, in
Now,
which it is said,
This list of take your
Yeah,
written notes.
yeah, my lord. This is a registered power of attorney. 40
Give
to
him a
14.
copy. Give him a copy.
I have given. It is given.
No, your written notes.
No, it's not written notes.
That what you have given to me today. Have you supplied him a copy?
I am giving, my lord.
Yeah, give it.
The third, mine copy is where one copy is missing. Office one, office copies will not get it. It is mine copy. Yeah, my lord. Kindly take it. Yeah. Kindly, yes, received. Yeah,
Mr. Pincha.
my lord, listen me.
No. Listen to me first.
My lord.
This is these notes has covered everything. So
My lord.
everything I will concentrate on these only. First of all, your Order 7 Rule 11 application based on number one, that it is the agreement is in violation of the lease deed itself.
Yeah, my lord.
Right.
My lord.
Now the other point of this act, you have abandoned it.
Other 2-3 point I can tell, my lord.
Please wait, try to understand.
My lord.
Therefore, the points now has come up may not be in your application itself, right?
My lord.
Mr. Pincha,
My
are you
lord.
following? The points now you are raising may not be there in your original application, right?
My lord.
Now
But these are the part of the
wait. These will come out from your this argument because these documents are admitted.
Admitted and relied upon in the plaint.
Exactly. Therefore, this can be looked into.
My
What you are required to do,
My lord.
you will file a supplementary application with your Order 7 Rule 11, specifying these are the points and these are the documents are required to be looked into
My lord.
to decide the point of maintainability of this suit,
My lord.
so that his client can meet your point
My lord.
properly.
My lord.
Now, tell me what are just show me the points
My lord.
so that instead of reading these one, he can respond quickly in his written notes of
My lord.
Just point out only outline. First of all, show me.
My lord. It is
Don't elaborate. No elaborate.
no elaboration, my lord. A registered will. It is a very important point.
Where have you stated that?
I have given with the in the written object written.
No. You concentrate on these. I will only read this. These written notes.
My lord, I'm giving. This is in page number 30.
Mr. Pincha.
My lord. It is page number 28.
I'm telling you about document.
Yes, document.
I am not telling you about the document. I'm telling
the facts of the document. Yeah.
Your statement in the written notes.
A statement in the written notes. Paragraph number 8.
Paragraph number 8.
H.
H. 8.
H. Page number 12, my lord.
Page number 12. Yes.
H. Paragraph number 8 of the plaint reveals that certain powers were given to and certain acts were assigned to OP number 1 by OP number 2 by a registered power of attorney.
Hmm.
executed between OP number 1 and OP number 2 on 20th November 2011.
Hmm.
The said power of
Okay.
attorney has been already produced by the plaintiff OP number 1 in the court below, who allowed the plaintiff to use it as evidence in her application as Annexure E under Order 39, Rule 1 and 2. As such, it has already become part of record of the suit and the plaint. I, that the said power of attorney was executed by both OP number 1 and OP number 2 under their respective signatures. The paragraph number 6 of the said power of attorney reveals that OP number 1 was assigned by OP number 2 to search an appropriate buyer of the suit property and to receive appropriate consideration of the suit property and to hand over the same to OP number 2 under proper receipt. These recitals of registered power of attorney puts a stopple on the OP number 1 that a consideration of rupees 7,30,000 was paid to OP number 2 for the suit property under agreement for assignment dated 4 December 2007, and such agreement is a product of clever drafting. As such, do not disclose real cause of action to sue. Paragraph number 6 of this power of attorney is reproduced here.
Wait for a moment. Wait for a moment. This is a suit by Mr. Roy's client for specific performance of an agreement.
My lord.
Now you are questioning the maintainability. This power of attorney relates to your purchase.
No. This power of attorney has been given by the defendant number
Say vendor.
Vendor and the this party, plaintiff, both. These are the both signatory of this power of attorney.
The power given to whom?
Power given to Asha Devi Bajaj, and
For-
Asha Devi
for
Bajaj
giving-
has taken this assignment, and she has been assigned to search, to negotiate for sale, assignment, and transfer the said entire first floor subject to the.
Understood.
Then in that power of attorney, it is specifically mentioned that this flat is not sold. This flat is not sold, and she is to search for a buyer, prospective buyer, and take consideration from him, and then give it to.
So this plaintiff once acted as a power of attorney holder of the vendor, admitted owner of the property, and the person with whom the owner had an agreement earlier.
No.
Means Asha Devi Bajaj's mother-in-law.
It reveals that there was no agreement at that time.
At that time, no agreement.
At that point of time, there was no agreement.
No agreement. Right. Understood. That point, at least at that point of time, the agreement which Mr. Roy's client now is paying was not in existence.
My lord.
Why are you complicating these things?
My lord.
Now this is the way you see, and you are now hinting towards what? Supposing there was no agreement.
I am hinting that this is a cleverly drafted, predated agreement.
Because agreement,
It is
power of
revealed in
attorney
the
is 2011. Agreement is of which year?
4th December 2007.
Oh, you intend to say that had there been a agreement in existence,
My lord.
there was no occasion to appoint the plaintiff as the power of attorney holder of the owner to search for a buyer.
My lord. And to get their consideration and to
Whatever.
My lord.
If the plaintiff had a subsisting agreement with the owner,
My lord.
why he would accept or would act as an agent of the
My lord.
vendor
My lord.
to search for a third party?
My lord.
That you want to say?
I want to say, my lord, exactly.
That is, you are questioning the existence of the agreement itself.
And it reveals in agreement also.
What, one by one?
My.
Therefore, you intend to say that the agreement is completely sham agreement. It has been manufactured for the purpose of suit.
My lord.
The manufactured agreement.
It is cleverly drafted. I will tell.
Don't borrow always. Supreme
My
Court.
lord, I will say it is cleverly drafted.
You don't borrow the language of the judgment, but say that this is apparent. A person who has a subsisting agreement with the owner, why he should act as an agent of the owner to find out third party buyer? That you mean to say?
My lord.
There was no reference of an existing agreement of
my lord
with the plaintiff and the owner of the property, at least in 2011.
And
when the power of attorney was executed.
and it
That
reveals that there was no consideration was ever made for this cell, which she is claiming.
in which way you say? Then the other point,
Then the
that
other
is a subsequent development.
subsequent development.
Then
Thereafter, my lord, the agreement itself.
you don't argue. Show it. This is one
Yeah.
point.
My lord.
Number 1 point, it was the original agreement. This is the barred. A sale was barred under the clause
My
of the
lord.
release deed itself.
My lord.
Secondly, 2011 document shows there was no agreement in 2007 with the plaintiff, with the owner.
My lord.
Third point,
Page number 6, my lord.
6. I was in
Four.
page number 13. 12, then again 6.
6, my lord.
Yes.
My lord, that in spite of getting direction from Honorable Apex Court, the plaintiff has neither submitted copy of agreement for assignment executed on 4th December
How it
2012.
affects this?
Eh?
How it affects the maintainability? He has not, it may be a blemished character
My
that
lord.
Supreme Court has directed, but they have not supplied.
My lord.
This may, but concentrate on.
Because they have misled this
Mr.
honorable court.
Mr. Pincha, I understand that plaintiff is a very bad plaintiff, but concentrate on scope of Order 7.
My lord.
One point I got, that your challenge to the existence of the agreement itself.
My lord.
This has been manufactured for the purpose of suit only.
My lord.
2011 document does not disclose existence of an, that little bit convincing.
My,
Just tell me the other point.
my lord.
And your agreement, this was been
The-
covered.
6, paragraph number 6. Page 7, my lord.
Oh, right to sue does not declare. Very well.
That both
No.
of the submitted unregistered agreement for.
Understood. Right to sue does not disclose. Right to sue.
My lord.
Paragraph 6 does not disclose the right to sue. Understood. Non-disclosure of cause of action. Covers Order 7 Rule 11. Then, Mr. Roy, these are the points you have to meet. That is why I'm just repeating it. I'm reducing your work so that you can respond properly instead of reading it.
No, I'm also reading it, my lord. Also reading it.
My lord, thereafter, that in instant, it is violation of clause 211, 2.8. This is written there. Deed of declaration, my lord. Page 11.
Now, deed of declaration is creation of a charge on government property.
No, my lord, I am not going on that point.
So you have written it.
Yeah, deed of declaration, the consideration paid in deed of declaration.
Mr. Pincha, you have written in page 9. Please.
No, I am telling that the consideration which is transferred into the this agreement of assignment dated 4th December 2007 is a transfer of a charge. I am telling that, and that charge is received as a consideration, and that consideration is also a charge, which cannot be done. On
That
this
is 55(6) of the transfer of property.
my lord. 6B of my lord. There is a decision.
So that is paragraph page 9.
That is I have to search.
Page 9 of your agreement.
Leased, my lord.
E.
Page 9. E.
10 হচ্ছে ওটা।
Property, yeah, my lord. It is a Sanchayita case, my lord.
E.
That contrary to relied upon judgment in the case of Vishwanath Sarma versus Shyam Shankar Goyla and others by the learned civil judge, in the instance case, the binding lease deed in public interest in its clause 211 prohibits creation of charge over the property without prior written permission of the government. In the instance case, paid consideration money for sued property in the agreement of assignment of the sued property creates a statutory charge on the demised premise under section 55(6)(b of the Transfer of Property Act. Creation of such charge requires mandatory prior written written permission from the government. In absence of prior written permission of the government, the agreement with such paid consultation is violating the public policy. Hence, it is barred by law in terms of section 23 and 24 of the Indian Contract Act.
Very
Yes.
well. Mr. Roy, when you can respond to that?
My lord, it's at the second week after vacation, my lord. I just finish a
You
note
have
on
got
this.
the copy?
Yes, I've just got the copy, my lord.
This is complete of yours. And the judgment you have
I will deal with the
annexed.
judgment. And if I can, my lord, before that, I'll hand over a note to him so that he can also go through my judgments.
And mind it that this will not be an elaborate discussion.
No.
I will be only giving you the grant you leave to file apart from the Supreme Court document, what you got the leave to file before this court, since Mr. Pincha is relying on some other more documents. All things will be relegated back to the court below, and I will scan that these documents can be looked into only
Well,
to decide the maintainability of the suit and do it immediately.
and that is what that's why I put limit it and your lordship will send it.
Mr. Pincha appears, sorry, Mr. Pincha, the petitioner submits his written notes on argument, copy thereof is supplied to Mr. Roy's junior. Mr. Roy pays accommodation to file his written note of sovereign on next date of hearing. Place the matter in the supplementary list on 16 January will do? 16 January.
That's to be mentioned, my lord.
Not as it will be. Very well to be. I will only
Yes, because
taking
your
the
lordship will
notes.
only decide to remand it, so my lord will kindly
এই
just-
ধরো। পরেরটা রাখো। Next one.
I'm grateful, my lord. আমি তার আগে দিয়ে আমি রেডি করে ফেললি আপনাকে বলে দেবো।
May it please, my lord, I appear for the petitioner, appellant in this matter, my lord. This is the second appeal. My lord, I have dates, my lord, on which, my lord, the learned senior counsel will, my lord, be available. If your lordship kindly fixes the matter, my lord, anytime, convenient to your lordship.
Where is your counsels?
My lord,
They are ready.
I beg your pardon, my lord.
Your counsels?
My lord, Mr. Shaha and Mr. Mukherjee, my lord, both, my lord, are, because it was to be mentioned today, my lord.
No, they are available. They are in the
My lord,
month of
that
January.
side of the vacation, yes, my lord, I have the dates. They have, my lord, indicated on which dates they are not available. So your lordship may, my lord, fix it to your lordship's
Your
convenience.
paper book to দেখি। Paper book to দেখি। এটা কি?
ওটা supplementary, পাতলা।
এটা নাও। Mr. Shah on additional question of law, না?
Yes, my lord.
এই ওই কাগজটা দেওয়ার করো তো, ও যেটা দুটো দিয়েছিল additional question of law। ওকে দাও, অনুপমকে দাও, বার করে দেবে। Suggested 2 additional questions of law.
My lord, initially there were 4 additional questions. Then my lord was pleased to, my lord, say that one question, my lord, there are 2 questions ought to be
Where
put
he has
together.
written
I will,
stuff.
my lord, indicate to your lordship. My lord, I find the earlier one is here. The one which was recast, that I do not find, my lord.
That I want to keep it with me in the paper book. You have got a copy of that?
My lord, perhaps not now, my lord, but yes, my lord, I do.
You have?
Yes, my lord. Not
Supply
with me
it
right
to
now.
them.
Can I, my lord, supply it during the
Yes,
course of the day, my lord?
supply it. What is the position of this specific performance suit?
My lord, the position, my lord, it is, my lord, for as far as I remember or I've been told, my lord, evidence is due to, my lord, begin.
Evidence of whom?
My lord, the plaintiff.
It's over.
No, it's due to begin, my lord. It hasn't yet commenced.
Why are you delaying that specific performance suit?
My lord, I am not dealing with that matter, but my lord, I'm sure, my lord, it's
You
not.
get information because there's a
I will-
direct
I will-
nexus with that.
My lord, on the next day, my lord, I'll get a proper, my lord, information slip as to what is the particular status of the matter today.
এই bro, ও একটা কাগজ দেবে, ওটাকে এই পেপার বুকের মধ্যে রাখবেন। হুম? নামিয়ে দিন, আমি বলে দিই আপনাকে সব।
My lord, my learned other side, my lord, has been very kind, my lord, to supply me with an extra copy of the, my lord, amended 3 questions, my lord, which was served upon them. So, what is there, my lord, consists of 3 additional questions which we want to urge.
Can I keep it?
Yes, my lord. My lord, I am told, my lord.
এটা নিন না, এটা নিন না, এটা দিয়ে দাও। ওদেরকে দিয়ে দাও, এটা দরকার নেই। I was hearing on these points.
Yes, my lord. My lord,
Whether at all these questions can be formulated as an additional.
if I may
question.
remind your lordship, my lord was of the opinion that the first and the third questions, possibly from the earlier, my lord, questions of law, ought to be, my lord, put together. My lord, these are the earlier additional substantial questions. And as far as the second and the fourth one were concerned, my lord was of the view that my lord will consider whether at all they form substantial additional questions or not. So, my lord, accordingly, the earlier,
এটা তো earlier.
yes, yes, my lord.
ও তো এই যে এইটা দিয়েছে latest one. হ্যাঁ। এটা ওখানে ঢোকান। The suit was not preceded by any notice?
My lord, the present one which is before your lordship, or my lord, the specific ones?
Present one, second appeal.
Present one. My lord, there was, my lord, a
It was
notice.
preceded by any notice?
My lord, not a notice, my lord, of eviction as such, but then there was a notice.
Vacate the premises. This type of notice was there.
It was, but my lord, I would rather, my lord, I come back with, my lord, proper. This came up, my lord, all of a sudden.
Second appeal করতে এসছে। না, ওটা রেখে দাও। 24 January.
24th, my lord, I'll just check the date. Yes, my lord, they're available. 24th.
Place the matter. Place the appeal for hearing the supplementary list on January 24, 2024 at 2 p.m.
Instead of 24, any day, madam.
Why?
Vacation, but holiday, madam, between the two.
24 January.
24th January.
Yes, yes. Within the
ওখানে ছুটি আছে না? 23 না। There will be only one day. মুশকিল আছে একটু। এটাকে আপনি 31st January next week করো। 2 p.m.
My lord.
31st January 2 p.m. No. The suits simpliciter for eviction of trespasser on the strength of title.
My lord, declaration also. My lord. Eviction of licensee, my lord, they have also sought for a declaration that they're the owners. And there's, my lord, a negative declaration also, my lord, that they have sought for that I am not entitled to the property. And my lord, I believe, my lord, there was, I will stop there.
The substantial question of law, my lord,
I don't know, Mr. Shah is propagating.
my lord, urged, my lord, that is, my lord, mutually destructive. If they, my lord, urge this, then the suit for specific purpose of contract goes.
My lord had indicated, my lord will deal with that.
Made the point. There is one point at last. Where is Mr. Chatterjee, the senior advocate? Oh, he doesn't appear in to be mentioned now after being designated.
Today, my lord, she's not out of.
He has not come. Where he has gone? Oh, Europe. Very well. It will be privilege of the court. He will be coming when. Ask him. Next one.
I'm grateful, my lord.
Therefore, I am beg to appear on behalf of the president.
Sir, I'm for the school service.
My lord, this matter, my lord, the selection and recruitment to the post of, my lord, assistant teacher in upper primary. After prolonged, my lord, the litigation, ultimately that in terms of the division major order, my lord, the panel was published. My lord, the impanel candidate, my lord, after verifying third and fourth times, interview process I participated and finally selected. My lord, in terms of the division bench order, panel was published. I took position in the panel. Lastly, I called for the counseling process.
But by the time you were overreached.
But
Not by the time. He was overaged from the beginning, but
Well,
that was ultimately detected at the final stage. That does
At the
not.
time of application, he was overreached.
Yes, so
Well,
that does not confer any right.
First time when
How the revision bench has said that your overage would be
no,
controlled.
this is the final panel because in terms of the High Court order condoning the age bar, he participated in the interview process.
Condoning the age bar.
Yes,
I don't
my lord,
understand. Where is that
this
order?
is the my lord, the kindly see the order.
High Court has condoned the age bar.
By condoning the because the rule itself says 2013 to 2015 there is no TET examination was held. So itself in the notification, this during that period there is no TET competition was that those are cross the overage, they are permitted to in the next selection process. That is the rule. Say, kindly see page 36, my lord. Page 36, my lord. Paragraph 4. The paragraph 4, the second paragraph, the provided that the candidate who have qualified TET.
Rule 4, sub rule 4.
Yes, my lord. Page 36, my lord.
Page 36.
Yes.
Rule 4, sub rule 4.
Rule 4, my lord.
Name, post, qualification and age. That is rule 4. 35.
35 is my lord clause. Yes, yes. Rule 4. Yes.
4 and 4.
4 and 4, my lord. My lord, the second paragraph provides that the candidates who have qualified it TET and possess valid TET certificate within the age limit shall be eligible for appearing in the next selection process under this rule in spite of the fact they have exceed the upper age limit.
Where from you are reading?
Sub rule 4.
Sub rule 4.
So the rule, read it entirely. The minimum age limit, 20 years.
Shall be 20 years of the maximum 40 years so long as the West Bengal service regional age limit rules 1981 in the force. Upper age limit of the however relaxation by 5 years of the scheduled caste scheduled tribes candidate, 3 years for the others backward classes candidate and the physically handicapped candidates as per the existing government norms. That is, age shall be calculated on the basis of first day of January of the year of the notification of the recruitment. And provided that the candidate who have qualified the TET and possess the TET certificate within the age limit shall be eligible for appearing in the next selection under these rules, in spite of the fact that they have exceeded the age limit. And thereafter, provided that the candidates have already applied for the TET in the name of 13 RLST within the above age limit in the last year before coming into force of these rules shall be eligible for appearing.
You are not 13 RLST.
Yes, my lord, kindly see, this examination was not held. My lord, the page.
No, you are under 13 RLST.
Yes, my lord, kindly page 23, my lord. 32, my lord. Is applied. It is applied but not held. That's why, my lord, this notification, the permitted is age limit
এটা কি 16
crossed, then he is permitted to the next selection process.
Oh, RLST 13.
Yes,
So,
But now, my lord, the kindly
এইটা লাগিয়েছে
kindly five page 75, my lord, 74 onward.
please wait. এই জায়গাটা একটু ক্লিয়ার করুন তো, পিকচার ফাইলে এটা যাবে। এটা না মানে এখানে একটু সাদা দাও, এগুলোকে নামান। একটা কিছু পিছনে রাখার দিন। একটা দিন yes,
my lord, my lord, and thereafter, my lord, they are aptly, my lord, the not allowed to participate in the, my lord, interview process. That's when a writ petition was moved. Page 74, my lord. Kindly come to say page 74. My lord, onward, my lord, the operative portion is, my lord, paragraph
wait,
3.
let me go through the entire.
সেটা তো সরি সাইড বিনা চেষ্টা দেখে দিবে না রিজেক্ট এটা
পয়েন্টের উপর তো আমরা অনেকগুলো তো সুব্রত মুখার্জি করেছিলাম না করেছিলাম page 60 huh? No, order to order.
That is 75.
75 ছিল তো কোন সময় order
Is 11 December 20.
হ্যাঁ এটা তো সেট অ্যাসাইড হয়ে গেছে তো
এরপরে তো সিলেক্টিং প্রসেস সেটা সাইড হওয়ার নতুন ভাবে হয়েছে এই জন্য রিলিজ করেছে
Yes, that
Is,
that
my lord,
part up to that limit it is
yes,
over.
my lord, thereafter this order complied with, no appeal was preferred. My lord, kindly come to page 77. In this case, my lord, there the, my lord, the 8 writ petitioner, out of which only this writ petitioner is come in the zone of cut-off marks. After considering the S bar, they selected for recruitment to the post of assistant teacher in pure science. Other than, my lord, the other writ petitioner, they are not come in the zone of consideration, not fulfill the cut-off marks. That's why only one candidate, this writ petitioner, is come in the zone of consideration. And subsequently thereafter, my lord, the matter was moved before the division bench. My lord, the kindly see the order passed by the honorable division bench, my lord. This is the order. Well, in this
Division bench approach from which order?
In this selection process, this challenge, cancellation, and thereafter finally decided by the division bench. In the division bench, কত number paragraph বলেন? Yes. Kindly come to the 47.
এখানে কত প্যারা 47
39 onwards, my lord. Sorry.
39 onwards
39 onwards.
Yes.
Yes, there is the, my lord, the affidavit of the School Service Commission. This list, my lord, they prepared the panel after verifying everything. Interview process, verification process. After that, my lord, 14,052 candidates selected for the counseling process. The counseling process is as per rule, my lord, only to allotment to school. Before that,
everything is
complete. So, my lord, if this, my lord, regarding the age bar, there is the other petitioner, they are not came under the zone of consideration.
They have been excluded.
Yes, they delete from the panel.
Then what is
Subsequently, my lord,
denial? Where is the denial?
my lord, there is no denial because individually served. My lord, this is only this petitioner came in the zone of consideration. That's why, my lord, the panel was published.
Where?
And petitioner page 80, my lord. Verification.
Yes.
This is the personality test. This is the call letter, personality test, petitioner participated. And thereafter, kindly page 81, petitioner was empanel.
81.
Yes, 860, my lord. CL number 860. Then, my lord, come to page 83, first page counseling. On 20th November 2024, she appeared in the counseling process. They said, no, you are the overage.
Dr. Patro.
My learned friend has placed the case in a very interesting way. The first order which my learned friend was showing, that is page 74. This is dated 16 January 2019. The relief which was given was an interim relief. My learned friend has not stated what was the fate of this writ petition. Firstly. Secondly,
yes.
Subsequently, this selection process in its entirety got set aside. My lord will recall while hearing under this determination, that is
secondary.
The upper primary, yes, the upper primary matter, the entire selection process was set aside and we restarted the selection from the stage 12-2. That my learned friend did not submit. Now, the rule which my learned friend was reading, that is the 2015 rule, which got superseded. Starting at page 33, though my learned friend has not given me, yes, page 33. This rule, my learned friend was placing the proviso of rule 4, sub-rule 4. But he applied under the 2016 rule. That rule was superseded. Kindly see
2016 rules.
Yes, kindly see page 59. This is a 2016 selection process. This my learned friend did not place.
No. He participated in the first RLST 2013. That started from here.
Yes, but that got set aside. Now my learned friend was relying on the 2015 rule, which was giving a relaxation, but that rule also got superseded. And ultimately, the selection process was on the basis of the 2016 rules, which is at page 59 of the writ petition.
Acha. What about the age relaxation in
the age relaxation has been taken away. Kindly see page 59. At the top, it has been stated that these rules are in supersession of the West Bengal so-and-so rules 2015. So looking at those rules, reading them, relying upon them is just a waste of time. Now,
Now
kindly
tell me
see-
under this 2016 rule, what is
yes,
the
he
position
applied
of,
under this 2016 rules.
position of this
Now
age
kindly see page
relaxation?
61. Rule 4, the proviso.
The same thing is there.
No, the proviso, provided that the candidates possessing valid TET certificates shall be eligible for appearing in the selection under these rules in spite of the fact they have exceeded the upper age limit, subject to the condition that the age of such candidate on the first day of January of the year of holding TET has been within the prescribed age limit. So the gap between the TET examination and the gap between the TET examination and the SLST, during that period, if he has exceeded the age limit, that will be accepted.
Therefore,
But he
must
is to be within the age limit at the time of giving the TET.
but she was
That
not
he-
there.
No, that
Because TET was not held.
yes.
The situation TET was not held.
No, TET was held in 2015.
But your case is
Applied, my lord, to second column, the applied not held. My lord, 2013, that is
Applied.
not it.
not held.
Those are
2013
within the
you-
age limit.
within the age limit, not held. 2015 held.
Held.
Then by the
So they
time
come in the zone of consideration.
you have your age has
Yes,
crossed.
yes. That is why, my lord, page 70.
No. As on 2015, the TET was held. That age overage candidates position was taken care of by the 2015 rules.
Yes.
No,
Because
yes.
2015 was prevalent at that point of time. A situation 2013 within the age, not held. Yearly held. 2014 not held.
Not held.
2015 held. And 2015 rules. That will be guided by 2015 rules.
my lord.
Now, in 2015 rules, if there is a age, yes, subrule for the proviso will regulate the age factor of the candidates of 2015 TET. Dr. Patro, consider and submit a report on this.
Very well.
So
I'll
that,
file an affidavit in opposition because similar matters.
I understand, but the selection test is over then.
Yes. My lord,
No, selection
23rd,
test is over. Counseling is also over.
No,
If
23rd.
if the petitioner succeeds, then he will be taken care of.
That can be.
That the court will
My lord,
direct.
one thing,
But there are other candidates also. We have filed similar
my lord, subject
affidavits.
to lordship correction, my lord. In High Court order, earlier High Court order, page 75, in paragraph 2, my lord, in this state, the petitioner clearly stated SLST 2016 appeared.
Yes, so my learned friend has to rely on
The
2016
point is
rules.
very clear. Now, at the time when you appeared in TET, you were overage.
Yes.
And your age was taken care of by the proviso appended to 4.4.
Yes, ma'am.
Now, you were allowed to, as if you are within the age.
Yes.
Now, 2015 replaced by 2016, which restricts that as on the date of appearing, if the candidate is within the age limit, then gap would be condoned. Here, if we take it together, 2015 and 2016, whether by virtue of proviso appended to 4.4, you can be considered to be a TET qualified within the time or not. This is the issue.
Yes.
Let me get the response of Dr.
That
Patro
would
on
have
that.
been possible if this
No, so one
2015
thing is-
notification was with regard to the TET. The
My-
2015 notification was also the selection test recruitment process
Then what will they,
notification.
but yeah, yes.
So if it gets
But
superseded, if it is
no,
not
no,
acted upon, no advertisement,
Dr. Patro, now the selection process of 2015 took care of the TET qualified who have overage TET qualified candidates.
yes, but it was never acted upon. There was no advertisement, there was no recruitment process. Rather,
No,
the
he-
following year it was dropped.
He is to respond. Now,
Yes.
you are restricting that as on the first day of the language is very nice in 2016.
Yes.
Uh,
Superseded.
the age of second,
Yeah, what-
1st January of the year holding date.
Yes.
Therefore, in 2015, 1st January 2015 held in 2015 TET where she participated. Whether
On that date, the candidate was overaged.
but on that day you are overage, but whether you can take advantage of 2015
Yes.
recruitment rule,
My
a
lord,
conjunctive reading of these two rules will get you out of this problem. Let him see
lord,
how the Dr.
may I
Patto
permit-
interprets.
my lord, in the order dated, my lord, 16 January 2019, my lord, the 2016 selection process, 2019 order was passed by the High Court, and that order was complied by the School Service Commission. After compliance of the order, I participated in the selection process.
No, that was an interim order. What was the
No, no,
final
this
fate?
is the compliance. Next page is the
Let me
compliance.
let you get the response, because so far, if I find that you are otherwise age bar is no bar, then he has to accommodate you.
But
He has to accommodate you.
one thing is the counseling process. My ask
He has to arrange for a
But,
counseling.
as per 17 rule 17,
Counseling is over.
counseling is going on. My lord. This is the,
Counseling
my lord,
first phase is complete.
14,000 vacancy,
First phase-
8,000 filler.
First phase
Without prejudice, can you
Hello.
kindly do not, because we're doing this pursuant to the division bench court's order. There were several SLPs which got
No, this is
dismissed.
SLP dismissed.
So we are carrying, no, not our SLP, by the candidates. So we are carrying it out as per the direction of the division bench. My learned friend
No, I
showed the division
understand.
bench judgment, but he did not say that his
Well,
candidate
I
has
state
nothing to
it.
do with that division
Well,
bench
this is
judgment.
the
This
this is the
age
complication.
relaxation is not dealt with by the
Well,
division
this is
bench.
the panel published
But
before the
Dr. Patto-
division.
The panel
Dr. Patto,
published by
Dr. Patto,
mistake
in
will
the
not come
ultimate,
for a right.
ultimately,
Even if you are recommended, you will be cancelled.
no, yes, at the again, even after recommendation can be cancelled. But Dr. Patro, in the event it is found that yes, he is doing, you have to arrange for a counsel.
Yes, yes.
That day you cannot say
No,
that.
no, if that has to. Either I comply with whatever comes from the court or I file an appeal. Again, I lose. Again, I come back to compliance.
My lord, the-
To reduce the work, can it be done, the counseling of this candidate without prejudice?
Kindly do not direct, because the
Complication will
second
arise.
counseling of the waitlisted candidates is ongoing. Tomorrow, Monday is the last date.
So Monday, Dr. Patro,
Monday is the
his
last
suggestion,
date.
yes.
Monday, if he allows without prejudice under the order of the
Kindly do not
Subject to
pass.
the result.
We will accommodate. If he makes
then
out a
will-
case,
that much assurance you are getting in the event you
My lord,
successful.
What happened?
we have to accommodate. How can we
Well,
not?
this panel, well, after verifying third times, well, School Service Commission filed the affidavit. There is no dispute in the panel. Everything
You
is
can say that the last moment.
My learned friend spent 6
I am-
months in
I
the
am
division bench
I'm
showing the
telling you,
dispute in the panel.
I'm telling you, prima facie you are successful in admission, because my prima facie reading is in 2015 TET she was overaged. A selection process was due, and 2015 rules was framed, prescribed that this will be the procedure to take care of overage candidates. No selection process was. If we conjointly reading the proviso to new 2016 rule and the proviso 4 to this, it leads to as if those were allowed to participate would be eligible to participate in the 2015 selection process. Why they should not be allowed to the same in here? This could be a logical logic on your part. Let me see how Dr. Patro's client reacts
I
to
will
that.
deal with
But,
it.
Because why I'm telling you, why I'm explaining it, I will be expecting explanation from that angle in your report.
Yes, yes, that is the only dispute. That is the only dispute.
The petitioner had participated in where is your admit card? Oh, this is first SLSC, na?
Yes, yes.
has participated in first state level selection phase for recruitment of assistant teachers within bracket upper primary level of schools except physical education and work education. Upper primary level except physical education and work education within bracket in government aided / sponsored schools. She was successful in the written examination.
Yes.
She was
An impanel, my lord.
and she's an impanel candidate of the said selection process, but has not been called for counseling.
No, call for counseling and then my lord not allowed.
He was called for counseling, but was not allowed to participate on the ground of that she is overage. Top para. It appears that counsel for the petitioner submits that she applied for teacher eligibility test examination 2013, but same was not conducted. Ultimately, she had participated in TET 2015.
Yes.
By the time she was overaged, but has qualified the said test. The petitioner in earlier round of writ petition. Where is that order? Page?
Page 75. My lord.
75.
74 onward, my lord.
What for you have approached?
Approach, my lord, they have not allowed to interview process. My lord, that's why I approached before the High Court. My High Court allowed to condoning the S-bar, but if otherwise she is eligible.
But Mr. Counsel, this order was passed in 2019.
Yes.
But it was not brought to the notice of the learned single judge that by the time 2016 rules has come.
But
This was an interim order.
appearing on the
It's
SSC,
not a
my lord.
final order.
No, this is that order is complied with.
Acha,
But next
fill up.
page, my lord, this is
No, I
complied
have
with.
to comply with an interim order. I'll sit
Yes,
tight over an
yes,
interim
yes.
order.
No, the petitioner complaining that she is not been allowed to participate in the selection test.
Interview process.
In the interview process, had filed a writ petition being WP 23603 within bracket W of 2018. In the said writ petition, interim order was passed on January 16, 2019. Directing that in the event an interview is held, the petitioner and the petitioners of the said writ petition come within the zone of consideration on the basis of the marks obtained in the TET examination 2015 and other qualification, the commission shall allow them to participate in the interview. In compliance of the said
Well,
direction,
I just interrupt. Here also the court has mentioned that this order will not create any equity in favor of the petitioner.
Yes, regarding the.
But he is trying to insert
Other
as such his right.
Other than cut off mark.
this is not finality, has allowed the petitioner to participate in the interview. And thereafter, it was even asked for counseling. She was asked to participate in the counseling. At this stage, the commission cannot reopen or disqualify her on the ground that she is overaged. Dr. Patro, the counsel for the commission submits that the order dated January 16, 2019 was an interim order, and same was passed with the rider that by allowing the petitioners of the said petition would not create any equity in favor of them. It further submits that the age that there was no select that the age relaxation on conceived of under Rule 4 under the proviso appended to Rule 4 of Rule 4 of the West Bengal School Service Commission within bracket selection of persons for appointment to the post of teachers in upper primary level bracket close rules 2015 has been superseded by the same rule লিখবে লিখে 2016 and the age relaxation contemplated under the proviso of new Rule 4 does not cover the case of the petitioner. Stop. To decide the issue, it is necessary that the Commission shall file an affidavit in opposition to the writ petition. Such affidavit be filed within a period of 2 weeks from after the reopening of the court on of the ensuing winter vacation. Reply thereto যেরকম করে করি 1 week. After 3 weeks, matter be placed in the list for final hearing.
One post.
Not necessary. He has to accommodate.
Yes, because when the second phase counseling is over, but third phase counseling will be started.
It is, if you are successful, then
That
he
is
has to-
neither here or there, whether there will be a third
is there
phase
and-
counseling or not.
No
Then
counseling.
my learned friend stops
And if I
speculating.
find that you are entitled to, I direct, you have to accommodate. them.
Yes, yes.
You have to arrange for a counseling. This is the understanding. There is no scope for any interim order at this stage. However, in the event the petitioner is successful in the writ petition, the commission has to arrange for a counseling for the petitioner to accommodate her.
Great. Let's take it.
That goes unsaid. That goes unsaid. It is not necessary.
No, for the satisfaction of.
Writ court will pass an order and we will not comply. That is impossible.
No, he has to. Otherwise, if you can take it, otherwise in the Delhi.
This is admitted fact.
Was not understood.
Third time is panel published, this is dispute also is.
I could not
Yes, yes.
respond.
No, you should be engaged. This is always expected. But Mr. Doctor, why I'm giving you the trouble?
Yes, sir.
Because of what I have find in this determination that the primary school teachers are getting DPSCs, respective DPSCs are the appointing authority. They are issuing their appointment letter. The nature of appointment letter is as if this is a contractual service. Terminable. Have you got any copy of the?
Yes,
In the
yes.
repetition only there is annex lodge.
Sir, at page 14, there's a copy.
In the repetition.
If you see, this is purely what has been written. Such and such plus other admission is yes, his or service terminable by 1 month's notice on either side. 1 month's salary will be forfeited if it has service such and such. So this is as if that purely temporary basis. And as you have rightly pointed out, so far the confirmation is concerned, the divergent views are there,
Right.
that whether it will be presumed to be confirmed or not. But fact remains, confirmation has got the other limb, that at the time of confirmation, if the authorities are required to see whether the performance of that teacher, how far is satisfactory, and other factors, whether he has been entangled with some other things, whether he can be at all be, his service can be continued or not. And if this exercise is not done, because I have found that after 14 years, a teacher is coming for transfer, and the transfer rule prescribed he must be a confirmed teacher. So what I'm thinking that if you take some steps for taking a conformity of this rule, so far these issuance of the appointment letters, this differs from appointment letters is ultimate of the education department. They are the employees of the everyone. The government is responsible. So if you can prescribe, you must have, the DPSCs are not so independent that they will be regulating their service terms, and who is issuing these memo. Appointment letter is a very vital thing for a teacher. This appointment letter must be in a particular format, if possible under a specific rules, that this will be the format of the appointment letter. Each DPSC has to follow that. And the confirmation also, if you find the confirmation letters, they are differing from one to other. And
primarily, two things are to be streamlined. One is the process of confirmation. There has to be a process, known process or a uniform process.
Uniform process.
And the other is the appointment letters. They should also be in conformity
with any rules, and there must be similar, because
if required, amend the rules.
Amend the rules.
Put a schedule or put a form or pro forma.
Whatever way, in whatever rules, there are several rules. In whatever rules, you may. And the confirmation, this also must be a regular exercise of the DPSCs, that after 2 years, they cannot be in limbo. That after 2 years, they are working, they are getting salary, they are neither confirmed. And it is so happened, a teacher has retired, not being, his service has not been confirmed. This whether it can be streamlined, what is your views and how it can be done? I want a view of yours. What are the relevant rules can be amended? How it can be done? I want a view of yours, that how you can do that and who will do that. The education department will do that, or don't leave it in the hands of the respective DPSCs.
No. It has to be, my lord, if it is brought in by way of a subordinate legislation, then of course, my lord, the normal process that it must get generated from the department concerned. Here it would be the education.
No, if you think that the administrative dictation of the education department will do, the henceforth you have to issue confirmation of the service confirmation in this way, and appointment format of the appointment letter should be this.
My lord, initially what I understand is, my lord, the law has to be framed. Whether it is by way of a primary legislation, whether it is by way of a subordinate legislation, that has to be done. Execution has to be left with the respective councils.
Councils. That is another part. If you prescribe under a law or any, I don't think that this may be a long drawn process.
Shouldn't be.
If you are not, then this will be either a legislation or a subordinate legislation framework.
Or even by way of executive orders also this can be done.
Yes, executive orders. But there
Because
must be.
there is no lack of legislative competence. Nobody will say that. Only is whether it should be by way of a subordinate legislation or an executive order or by.
But one thing is necessary somewhere which all the DPS is required to follow. That
Yes, that's
after
what I
2
said.
years,
Yes, yes.
the confirmation of the teachers must be a regular process. Now they are under the dictation of this court are doing it rampantly without knowing. That is not possible now. They are collecting data and they are now giving the confirmations. Those who are coming for mutual transfer, even when I'm asking them to submit their confirmation status, by that time they are using the confirmation letter now. But this cannot be the whole object of confirming an employee of yours, to see whether his performance is good.
Satisfactory.
If it is found that this teacher is involved with something which cannot, his service cannot be confirmed, the provision of appointment is very clear. 1 month notice you go. Not even a disciplinary proceeding is contemplated if the nature of appointment letter is such. Not even he can say that a disciplinary proceeding should be initiated against me. This is the one aspect of the matter. The other aspect is what I'm in the other way in the secondary section. The data of these teachers are not available. Under which DPSC, how many schools, how many senior service teachers, in which selection process they actually appointed. This is not a big task at all. Now, I have directed all these almost 23 district primary school to 23 to 25. Data they are supplying, Mr. Dotto. What I am proposing, all these data will be given to Commissioner of School Education. He will cross-check and verify it district-wise, and a central portal may be created. Apart from Bangla Shikha portal, it is not being updated. And if you can repose confidence on board, that board you maintain a central portal where the in-service teachers' details will be available. It will be easier for the board also to detect the vacancies in case of selection. It will be easier for everyone to detect even a case of even the transfer. That if I give this teacher to this district, then the position of PTR of this school will be this. I know the cost involvement, but this has to be affordable. It has to be. And I want that it should be routed through Commissioner of School. What is your suggestion?
That can be done because Commissioner of School Education is the highest person so far as the supervising the school
administrative sides and everything. Instead of, you can involve the education secretary also, whom you think. I'm giving you that. You take up the issue with the concerned officers. And please, after vacation, apprise me who will be the appropriate authority to take up the issue. The data has already been collected. Every DPSC is submitting the data. A copy I'm keeping here, and a copy will be supplied to your client, whoever would be. And he will take the exercise and tell me that how far, how soon. Because the board may not have the control over DPSC in all sense. But the board being the central authority can keep it. And commissioner has got so many other things to do. So it will be better if the West Bengal Board of Primary Education keep this portal in their surveillance. And they are obliged to provide all informations to everyone.
Right.
Because so many schools, there are really healthy schools, so many students. But in some schools, they are about to be closed. And the third one, and the most vital one, the rationalization policy. To frame a rationalization policy, I need your help. From that data, you will be finding that in a district, a school of 2 students have 4 teachers. So if you frame the rationalization policy and if you implement it, like secondary one, that that secondary rationalization policy, 10C goes, challenge to 10C goes now. And there is a specific provision 19K, I think, of the administrative power of the board.
No, act.
Act itself.
Act itself.
Education department has got, commissioner has got a specific administrative power to order transfer. So under 19K, you can frame a rationalization policy like this secondary one. Tell me, yeah.
My lord, for that, my lord, why in primary school, my lord, this happens, my lord, because suppose, my lord, there are 2 teachers and 100 students. It is within pupil-teacher ratio. No, it is excess. Teachers are
60,
less.
60.
Suppose students are 50 and teachers are 2. My lord, a new recruitment process initiated. In this school, another 4 teachers are appointed, but 2 teachers are appointed. This is one problem. So at the time of identification of the vacancies, that to be recognized, taken into consideration. Another thing, my lord, every year, pupil-teacher ratio changes in primary school. Suppose, my lord.
Not every year, every day.
Not, I am telling every year. Why, my lord? Kindly, suppose there are 100 students in a school. Some students go to the higher section, that goes vacant, and the new admission, suppose in a particular year, the new admission in a school comes only 20. So it will decrease. Again, the next year, it may go to 200.
It may be the failure of our society. I should not blame the state itself.
No, it's
that
nobody
they
to
are,
blame, but this is a
failure
fact.
of the society. I have seen some school in Jalpaiguri overwhelmed with the teacher. This secondary section is crying, please don't admit in the primary sections, because RT Act, you have to feed the primary section, pass out cannot be denied to be get admit in the secondary section. But in same thing, just few meters opposite to river, another school full vacant. What I did, Mr. Dotto, I asked everyone to come. They are saying separate dice code. Well, forget about this. This will be the second campus of this school. Here, a student is sitting on the floor. The child is sitting on the floor, and the other, just opposite to the school, another building is totally lying vacant, and you are showing the dice code under the same DPSC. So these are the things when it can be looked into, and you are saying the pupil-teacher ratio still primary school has got some good health in the data. I have seen this district-wise. Some areas are really pathetic. That is whose fault, I don't know, in which way it has done. I'm not overburdening him with the other portions of the syllabus and other things. Good schools are there. So, Mr. Dotto, please tell me by which time you can get me back with this information.
2 weeks after the vacation.
I'm not recording it because I'm
please don't record
apprehensive
anything.
of this
My lord,
publication.
only 2 things, my lord. First, if it is possible for your lordship, keep the matter pending, and since both the teachers have already confirmed, let their mutual transfer be processed and keep the matter pending where the learned advocate.
Mutual transfer reports I'm waiting for.
No, it has been given. Both the teachers are confirmed, my lord. Reports have already been filed. And second
will
thing,
reach to board.
No, then your lordship has to.
Yes, I'm sending it to board. Let him consider for 2 weeks. By the time.
Yes, man. And my lord,
I
another
get the
submission, my
advertence.
lord, this can also be taken care of by the learned advocate. On the last occasion, my lord, your lordship remember the practice and procedure of 1991. What shall be, whether at all that
matter, your lordship was fixed on 7th.
No.
HON'BLE
No. I'm not going to overburden you. There is a really critical situation. A really critical situation.
ওটা আগে
After
আসুক।
the amendment of
তুই একটা একটা করে কর, একবারে সব।
না না ওই মামলাটা
এতে
fixed
চার্জ
করে
না,
দিয়েছে।
পুরোটাই-
Your lordship has fixed it on 7th.
Sanal is addressing on that.
ওটা কবে
The amendment of Rule 8, effect on the practice and procedure framed in 1991. No, I want that part, he should not be overburdened with all the issues. Can I fix it on, can I get you, Mr. Dotto, can I get you on 16th? Hey, 16th থেকে কি রেখেছি? তাহলে একটু আগে। 23rd January will suit you? Oh, sorry, 23rd. Sorry, that still this is a holiday.
Somebody went to,
4th and 27th.
somebody, some so-called promoter went to Netaji's house in that Iliad Road. He wanted to promote that building. So he rang the bell. Someone had asked, "Who are you? What do you want?" "I want to promote this building." So the lady said, "You know whose house this is?" He said, "Whose?" "সুভাষ বোসের বাড়ি। ওনাকে ডেকে দিন, ওনার সাথেই কথা বলে নেবো।"
These characters in the cinema are coming from reality. And I was watching the movie Bhuter Bhovishot. There's the dialogue of the promoter with the local it's a marvelous one.
Yes, yes.
My lord, except 24th and 27th.
Sure না। তাহলে ফেব্রুয়ারিতে রেখে দেন একবারে।
No, no, no.
24, 27.
January 30. January 30. You are getting enough time, Mr. Dotto.
But
Please
I
do
think
it.
something is fixed on 30th. Could it be 29th? I don't know whether it's a working day or not.
29th?
Wait.
Yes, sir.
My lord, in the meantime, your lord.
Yes, I'm doing it. Yes, Mr. Dotto. You are relieved. এখানে লিখো।
হুগলি রিপোর্টটা আমাকে দে আর তোদের
Reports file.
Yes.
Reports has been filed on behalf of Purbo Bardhaman District Primary School.
All details report. 2 copies file. 1 copy will go to.
Your lordship, not the general report. That is
That I want. I mean, one thing that generally 1 copy will go to Commissioner of
that
School
is a
Education.
500 to 600 pages report.
Well, may I
That
take your
may be
lordship?
supplied in a soft copy format to the court's email ID or something. Then your lordship kindly gives us time till the next date. We will file the hard copy.
না এই মামলাটা রিপোর্ট
এই মামলা report দিয়েছি।
Well, so far 2 districts are concerned, but I
This
have
report
filed
has
2
been filed
copies,
by
my
both
lord.
of you. Where is that?
let me have a copy of the report, my lord. Immediately I'll send it to the board and come back to your lord.
The chairperson.
এ তোর রিপোর্টটা দে। The
DPSC. Who are the 2 DPSCs involved?
Yes,
My
my
lord,
lord.
DPSC Hooghly, my lord, already sent, my lord, that he has been confirmed, my lord. That is the only query by his lordship, my lord.
Similar report has been filed by the Purbo Bardhaman chairman as well.
That your lordship
Confirmation.
record it, and my lord, on the basis of that record, my lord, that orders, your lordship, today's order, my lord, will proceed with the, my lord.
No, Mr. Bosumoli.
My lord.
In your instruction, what you have received from the chairperson DPSC Hooghly,
Yes, my lord.
he has stated that his service is confirmed.
Yes, my lord. That is the only query made by his lordship, my lord.
No.
And so far that
I want, yes, he has written as commentary on 19K. I do not want that.
No, only thing lordship may omit those. Lordship may only draw the inference that he has only things that whether he has confirmed or not, he has confirmed. That is the only
No,
thing lordship may
confirmed.
take.
Now, supposing in case of a mutual transfer also, whether it has got any adverse effect on the students' learning process or not, that your report is silent.
That is, my lord, because we have already filed the entirety. What has asked by his lordship, my lord. I think 50 pages document have already been filed by my lord, my lord.
Same. Confirmed teacher. So, board, your representation is where?
My representation. 21. One is at 7. One is at 27. Sub-inspector of 21 and 20. 24 is also there. 21 to the chairman of the PSC, and 21 is to the, and 18 is to the chairman Purva Bardhaman.
No, 21 is secretary.
I have given all those, everyone. I have
Secretary, West Bengal Board of Primary.
both the petitioners have given separate application to the secretary and to the chairman.
Chairman.
Kindly come to page 18.
Page 18.
And your lordship consider page 18 and page 24.
Chairman Purva Bardhaman.
And page 24 and 26.
Practice examining item 36. I'm not in 36. Same college, same matter. I'm not in 36. I want to see that. Let me see your.
So both of you send it to board
Send it to
with your comments.
Common order.
তো বার করে দাও কারেক্ট অ্যাপ্রোচ যেটা আছে মিউচুয়াল ট্রান্সফারের অর্ডারটা দাও না No, now the practice procedure part I am not following. After this rule 8, after amendment. So only 19K he will consider these two repetition. Mr. Dargupta, make necessary correction over here. I have practice procedure part I have deleted. The only thing that both of you shall form your opinion regarding the representation and send it to the board, and board then shall send this to West Bengal Board of Finance for consideration prayer petitioner for mutual transfer in accordance with law.
My lord, kindly fix a time, my lord, kindly.
And board shall complete their drill in this regard specifically within 4 weeks from the date of receipt of the opinion from the councils.
And my lord, the council will send it to the board within 4 weeks. 6 weeks. Yes, council will again.
No, they will form their opinion and they will send it.
Within, my lord, otherwise it will never be sent unless it is sent.
Shall
Board
form
cannot
their
use
opinions.
immediate.
এইখানে না within a period of 4 weeks from date. Both of his here and shall send the same.
And my lord, kindly make the matter returnable on 29th.
Yes, matter be placed before the supplementary list on 29th January 2025 along with the report of the board.
My lord, at 10:30, Mr. Learned Advocate General is appearing. As item
Let
number
it
one.
appear.
As item number 1, then, my lord.
As specially fixed matter. Heading to progress.
Grateful.
এটা রিপোর্ট দিতে হবে বুঝলি ওরা রিপোর্টটা দিলে সেই অর্ডারটাও কমিউনিকেট করতে হবে তাহলে ইয়ে হয়ে যাবে বোর্ডের রিপোর্ট বলে লিখতে হবে যে আফটার গেটিং অর্ডার
না ওকে দিতে হবে বুঝলে কাটাগুলো ও দেখে দেখে করবে ওইগুলো বাদ দিয়ে দেবে তুমি না পরেটা
Get up.
Five I appear for the state lordship.
দেখি দাও তো setting aside the amendment. Who is this Malavika Roy?
Lordship, she is the grandmother,
Appellant respond.
appellant,
Sole appellant.
sole appellant.
এই দেখি পেপার উঠে দেখি বা মেমো অফ অ্যাপিল যে কোনো একটা কিছু দিলেই হবে হুম এই আসো none appears on behalf of the applicants applicants on the date of sole appellant the appeal has already been abated can 1 আর can 2 টা লিখবেন ঠিক আছে অর্ডারটা কিন্তু can 1 can 2 এ হচ্ছে these are applications for substitution of the heirs and legal representatives of the deceased appellant and can and এটা can 1 এটা can 1 of 2020 can 2 this is an application for setting aside abatement none appears on behalf of the applicants
For the second
Motion
time.
is paid for
Today is the second day. Nobody is appearing, and this is how the matter got abated also. They're just dragging it on, Lordship.
as the applications are dismissed formal abatement of the appeal is recorded now division dismissed the lower court record be sent down immediately stop dismiss for default
Grateful, Lordship.
এইটা না ওই মামলাটা এখন ডক্টর পাত্ররা যে মামলাটা অ্যাপিয়ার করেছিল ডক্টর পাত্ররা ওই ফাইলের এটা এটা পাঠিয়ে দিন
Condemnation-টা
এটা পাঠিয়ে দিন তাদের হাসপাতাল
ঠিক আছে, সেটা যখন
এটা হবে না এটা পাঠিয়ে দিন কেটে ফেলতে হবে নেক্সট ওয়ান Series down.
সেও নেই তো কেউ
আরে দেখুন না ক্যানটা ডিসপোজ অফ হয়েছে কিনা হ্যাঁ স্টাডি করে নিন এখানে যদি অ্যাবেটমেন্টটা যদি রেকর্ড হয়ে গিয়ে থাকে তাহলে তো আর দরকার নেই এমনি হয় সাত 7 I'm for the state.
7, my lord, I am filed 2 application, can 1 and 2 for addition of
My lord,
party. Yesterday I got a leave.
my lord, it will take some time, my lord. I received the brief, my lord. I am
I'm for the
got
petitioner, my
instruction
lord.
from the
There is no
Your lordship,
urgency at
kindly
all, my
fill
lord.
over after
Issue
vacation, my
pending before the SLP, my lord.
No, no,
yesterday
my lord, no,
on
my
7th
lord,
January.
no, my lord, no.
Yes, yes.
And I
That is
attached the copy.
different, my lord, altogether, my
Not
lord.
different.
No, my lord, that is altogether, my lord, different, my lord. Different issue is pending, my
Are
lord.
you
No,
objecting
not
to
different.
addition? Are you objecting to their addition in this
My
matter?
lord, I don't know, my lord, who are they, my lord? They are
And how you are objecting?
my lord, they are not in.
Are you
not
objecting to
yes,
addition?
Yes, your lordship.
Then file your affidavit to the application.
No, no, my lord, kindly
Yes, yes.
ask my lord, hear my application, my lord, then my lord, whether
I
they
attached
will
the
catch
copy
or
of this Supreme Court, my lord, Honorable Supreme Court. The date is fixed on 7th January. This is my writ petition where, my lord, the NIOS candidates, my lord, has been rejected by the Honorable Justice Rajashekar Mantar.
No,
Appeal
what
has been
not.
deferred.
Clarification.
Subsequently, appeal court affirmed the order of the Honorable
the
Justice Judge.
application for addition? I am hearing it today, the application,
Application.
not anything else.
Yes.
Are you objecting to their addition?
I will not go through the.
Please go through it. If you want to, file your affidavit to the
My lord, in my writ petition, my lord, first time I am concerned about my writ petition, my lord.
But the petition has not come. Has come for the application on his prayer. The petition I'm
My
not going to
application
touch.
is that, my lord, 18 months course is not the valid course. Review has not.
Oh, is he opposing me?
Yes.
I am on
Absolutely.
threshold. What right he have
Absolutely
in my writ
opposing.
petition? What right he have? No, no right at all, my lord.
Let them file my affidavit.
My lord, my lord, I on threshold, my lord. My lord, I am opposing it because of that, my lord. They have no pre-existing right. Whether he participate in the selection process or no.
These are the applications for addition of as respondents. Addition of the applicants in the writ petition as
It
respondents.
can be allowed, my lord, without affidavit because, my lord, I am appearing
My lord, I
in
am-
the selection process. We are the appointed candidate. Also.
I am opposing vehemently, my lord.
Samim, an advocate for the petitioner submits that the applicants are neither necessary nor even a proper party to the present writ petition. Sleep to file affidavit in opposition to the said application.
মানে কি মিলিজুলি মামলা তোমাদের সেটার সাথে?
Let such affidavit be filed within a week after the reopening of the court from the ensuing winter vacation. Within a week.
My lord, why my writ petition? My lord, I came with this writ petition with prayer of leave. Why? My lord, why? Because of that. Because of that, my lord, the 2020 selection process initiated in the year 2022. And my lord, kindly, my lord, take this writ petition. Why I came with this writ petition? Initially, that was the eligibility criteria. What was the eligibility criteria? That is mentioned page number 44.
No, wait. X was the eligibility criteria. Supreme Court subsequently says that this cannot be the eligibility.
No, never. Never. They misconstrue it.
Very
So,
well.
yes.
Therefore, to understand the Supreme Court judgment is to be read
Yes.
in detail.
My lord, kindly take my writ petition. My lord, no, my lord, then my lord, they ought to, the selection process ought to stop, my lord. Why? Because of that, they're not considered, they're not rightly read the Supreme Court order, my lord. Why I say so, my lord? Because in mass, my lord, kindly, sorry.
Come down.
Sorry, my lord.
Now, this relates to interpretation of the judgment of the Supreme Court. Whether actually Supreme Court intend to exclude your clients, that means NIOS candidate or not. This was your interpretation. And according to you, the appointing authority rather misconstruing the judgment of the Supreme Court to exclude this. Now, Mr. Chatterjee's client, who are not the opposing,
regular DLH.
they are opposing that you should not. No, you have got it.
Who are they? We have completed our courses.
In my writ petition, they want to add as a party.
Mr. Samim, therefore, you have got two hands in two sides.
Yes.
You have to.
I oppose by both sides.
Yes. You have to stop the water flow from two ends. From the two ends. Now, This
No, no,
time,
my energy
this
is always
time,
high, no
this
doubt.
time, this time, Mr. Chatterjee will be supporting the board. I suppose so.
Yes, yes.
They are,
DLN special features. for
yes,
them. I know.
they are apprehensive.
For the
If
board.
you have been allowed, then their future will be
No,
at
not
stake.
at all. Not at all.
Can one, your
Who are
lordship,
they?
the
Whether they
applicants
are-
herein,
Is also there.
can one, your lordship, herein
Madam,
we are not yet
I put
appointed
this
and we
question
are
to
the
them.
DLA 20 months. We are also opposing.
I put
For
this
their,
question.
for the, but it is in the Supreme Court. Let us
Lordship,
see.
lordship.
That's why I'm saying.
I put
The
this
18
question
months
whether
or
they are
20 months?
selected, they are appointed or not selected.
Give your opinion.
Yes, well, if they are not selected, not appointed,
Lordship, any day
so
we are the
what
necessary parties.
case they have?
When the Supreme Court has fixed it,
7 January.
7 January.
Mal-
Only issue is whether NIOS
No,
candidates.
For after admission issue notice, matter will be appear on the non-miscellaneous day.
No, understood, non-misleading. But what was the issue over there?
Issue রাতুল আমি একটু বলে দিই
24
Therefore, the fate of these writ petitions largely depend upon the.
Yes.
In that petition, at that point of time, Supreme Court review order was not there. First. Second thing is that, my lord, kindly, if that is the submission of the board, then my lord, kindly keep 6 post vacant. Otherwise,
Why?
they came with, you are not board.
Why?
You are not board. You are.
I am
Mr.
Samir.
What is there?
I have completed my courses, regular courses.
Wait.
The board.
We were not in the same footing of that. Those petitions who have been rejected already, SL to Supreme. You want to distinguish your position.
That's why.
How?
Because of that, my lord. At that point of time, my lord, there was no such review order, my lord. Kindly take the review order first. Clarification, page number 107.
So you are protected by clarificatory order.
Yes.
That is your case.
Yes, my lord. And not only that.
How?
Kindly take the page number 107. For once. Para 3. Specifically, para 3 and 4. Is one of the fantastic case, my lord. And the end exclusion is very bad.
You are in employment. Already you are in employment.
Yes. In employment in unaided school, there is 3 types of school. Government school, government aided school, and unaided school. In the under section 2N.
Mr. Biswas, the applicants here, the petitioners are covered by this clarification.
My lord, that is why, my lord, I need instruction, my lord.
When?
Yes, my lord.
January.
After 7th, your lord.
Of course, after 7th. January.
My lord,
Not in date.
My lord, kindly look to my lord page 41 once. My lord, let it be after vacation. Kindly see my lord page 41 once. The certificate issued by the.
Yes.
ও রেকর্ড তো আর কেউ চেঞ্জ করতে পারবে না পেজ 41 but kindly see the headmaster of the school saying that kindly see the date 1st January 2015 to 31st December 2024.
Yes.
The period has not been elapsed.
Yes.
We are on
No.
the party
My lord, kindly take the online application. No, kindly take the online application.
Mr. Saming, first register them by filing your affidavit.
My lord, kindly see. It was NIOS DLED was the 1 year window, and in online application is a one time, my lord. It is from the dice code. No, not at all.
After 4 months.
My lord, kindly see, my lord, kindly what was the scheme? What was the scheme of 18 months? Kindly take the Jivhising
I
judgment.
will see everything.
My,
At the time, finally, on the
my lord, on which date, my lord, then only 6 posts vacant, my lord. Otherwise, my lord, they will come with
that you will be getting your job. Next one.
no more, not at all, my lord.
So you will be getting 2 weeks time, 1 week for reply on the application.
I on that, but on the writ petition, my lord. Kindly see, my lord, the writ petition, my lord. But otherwise, my lord, it will be, my lord, kindly.
Nothing will happen, Mr. Samim.
My lord, I am not on the application. Whether application would be entertained or not, that is secondary matter. But what about my writ petition, my lord? What is my writ petition? Give the instruction on this record.
My lord, you give the report in this.
You file your opposition
My-
by 2 weeks after vacation.
Yes,
No, no.
Yes,
no,
my lord.
No. This is a case where you have to.
my lord, yes. Give it on a, yes, give it. Yes, yes,
Enough time for both.
yes, yes.
Enough time for.
My lord, 2 weeks. Extremely grateful, my lord. Reputation. 2 PM matters, item number 13.
দেখে নিন ফালতু তুলতে হবে না।
Paying for area from CPF to GPF minor. Seventeen I am for the petition. CPF to GPF. 18 also my I am for the petition. 19.
I am for the state, my lord. I'll make District South.
স্টেট
District South is the discount summary.
দিয়েছেন? আচ্ছা ঠিক আছে।
I am for the petitioner, my lord.
I am for the state, my lord.
Only CPF very open.
Dada.
I am for the petition. Petition का मतलब CPF पे जिक्र।
I am for the petition, lordship, CPF to GPF.
I am for the interest of gratuity. Local 39. I am for the state. I am for the petitioner, Rupa 2009. I am for the petitioner, Rupa 2009.
বন্ধ করে দাও।